Yeah. Very well. We have fun.
I said, can you see the page?
I see the comments.
What? You didn't even turn off that.
And they give me the option to.
What are you saying, Chris?
I'm only seeing the image.
Oh, on YouTube as well. And,
He's only seeing the bench.
well, on YouTube, so it's fine.
Oh, okay.
This is on his end. Turn the comments off of this without any.
Or what are you viewing it through?
Zoom.
Oh, yeah, no. Yeah, you need to be looking at it on the website. Yeah, I'd get out of Zoom.
I started out balance. Those guys who not some. Yes. So what part of obviously all the sixth district of the state of Florida is now in session. The Belsass of Chief Judge presiding. All persons having business before the court draw no give attention and will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Good afternoon. Thank you all for being here at our very first oral argument sessions ever for the 6th District Court of Appeal. Big moment for us. It took a lot of people doing a lot of hard work to get us here. So we are thankful to all of them for their diligent efforts. I'll start with introductions. To my right and your left is Judge John Sargel of Lakeland. To my left and your right is Judge Mary Alice Nardella of Orlando. I am Meredith Sasso, also of Orlando. I'd like to remind everybody to please silence your cell phones. Also, please be cognizant that these proceedings are being streamed live on YouTube. And with that, we'll call our first case. First on the docket, we have 2344 Fiddlesticks Country Club versus Perry A. Potter et al. Mr. Shepherd? Sorry? Okay, great. And I will reserve 5 minutes of rebuttal unless I hear to the contrary.
Thank you very much. May it please the board, I'm Steve Brannick of Brannick, Humphreys and Berman, here representing the Fiddlesticks Country Club. I'm going to be splitting my time today with Mr. Shepherd. He represents the amicus in the case. I'll be taking 16 minutes, he'll be taking 4, and then I'll take my 5 minutes. So let me get started by saying it's a real honor to be here on this historic day for the court. I think we're starting off with an interesting and important case. It concerns the enforceability of a bylaw amendment that was adopted by the majority of the members of the Fiddlesticks Country Club. The trial court entered a sweeping order ruling that the amendment was unenforceable because each member had a, quote, vested right, close quote, in the form of the bylaws when they joined. We think that ruling was in error. First, under this logic, every amendment would be unenforceable as current members. But every case in Florida has recognized the right of membership associations and country clubs to adopt amendments in accordance with a procedure set forth in the bylaws. The modern approach by both courts inside of Florida and outside of Florida is to give great deference to those bylaw amendments. The Fourth District Court of Appeals is a really good example of that modern approach. There's 2 cases that we've cited, the Share v. Broken Point case and the Hamlet case, both of which say that there is no vested right of the members in the bylaws when they join, so long as the members know when they join and the bylaws state when they join that the bylaws are amendable, and so long as the association follows the rules and amending the bylaws.
So is your position that there could be vested rights in some organizations and some bylaws, but they're not in this situation?
Well, we have 2 points we're making. One point we're making is that this court doesn't even need to look at the vested rights issue because under the modern case law, courts give deference to those bylaw amendments that they find no vested rights whatsoever, unless the amendment is arbitrary, capricious, or bad faith, or was entered in bad faith. And there's no argument about that here. So under that logic, you wouldn't have to reach the vested rights to sit.
So is that,
Isn't that just another way of saying that a right that emanates from bylaws that by their terms can be amended is by definition not a vested right? Or do you see it as broader?
Yeah, exactly. I think that's what the courts are saying, that when you go into an organization and you sign up to a set of bylaws, and the bylaws tell you that they can be amended as long as the organization does A, B, C, and D, and the organization does A, B, C, and D, you don't have a vested right, just as a citizen doesn't have a vested right in the common law as it currently exists. The cases are.
So I guess couldn't both be true? You kind of frame this as 2 paths we could go down,
Right.
But are they really mutually exclusive? So in other words, if a right that emanates from bylaws that are subject to amendment is not a vested right, that could be true. Also could be true is that bylaws that where an amendment affects a vested right is invalid.
Exactly. You could certainly determine that there is no vested right here because of the right of an amendment and because every member who has joined the club has agreed to that amendment process, and there's no dispute that the amendment process was followed properly here. So again, that's exactly what.
if the bylaws provide for classes, and I'll have a follow-up to that, is there not then some obligation within the organization to make sure that the tyranny of the majority doesn't overtake those classes? For instance, somebody, if the bylaws said, if you joined at this point, you get one benefit. If you join at this point, you get another. But then they let in enough other members, they come in and they overtake, they outnumber and outpower by taking rights. How do you deal with that in your idea that there's no vested rights.
Well, I mean, I think everybody goes into the organization with their eyes open. There is a process for amending the bylaws. But just think of if the opposite were true. If there is a vested right in the bylaws as they are in place at the time you join, you would be tying the hands of every membership organization in the state. Times change, economics change. These organizations always face significant economic challenges. There's only so many ways to raise revenue. You can do dues, you can do special assessments, you can raise the amount of the equity certificate. Those are all complicated decisions that are best left to the membership themselves. And so that's exactly what happened here. We had a membership proposal. There was a determination that it was just way too expensive to join this country club. And as a result, the resale value of everyone's units were going down. So they needed to find a way to fix that. You fix that by raising dues and lowering expenses. You do it in another way. So the board got together, they formulated a plan, they shared that plan with the membership. It's a very detailed plan. You've seen it in the record, explains in great detail exactly why they're doing this. Then the members got an opportunity to vote, and the majority voted for the amendment. There is no suggestion that there was anything improper about the amendment process. There's no suggestion that the club did not follow its procedures. Why in the world would a court suggest that a membership club's hands were tied and could not address the economic realities that the club was facing? So
if this court takes the approach that essentially the bylaws, because they're subject to amendment, don't create a vested right, can you square that rule with the first Florida bank case? You're familiar with this one where
yeah, I mean, so as I talked about in the brief, we've got sort of two different approaches. We've got the slightly more restrictive approach by the second DCA in cases like that first Florida bank case, cases like the Veranda case and that federal case, the Feldkamp case, which was relying on the second DCA precedent. We've got that as compared to the fourth DCA precedent. First, we think the fourth DCA precedent is more persuasive, better reflects economic realities, better allowed. It recognizes democracy and allows the members to do what they need to do in order to keep the membership organization working properly. But in that first Florida bank case, an important feature of that case was that there was a bylaw amendment, but that bylaw amendment attempted to amend the charter of so essentially the constitution of the organization. There was nothing in the constitution of the organization that suggested that it could be amended in that way. So you had a procedural problem. And unfortunately, that first Florida case that you've seen is only one paragraph worth of analysis. It doesn't talk about any of the cases. It doesn't talk about any of the differing approaches. So I think that's best put aside, as Judge Klein did in the Hamlet case, by saying that in that case, they were trying to amend the charter as opposed to amending the bylaws.
you don't think that would necessarily present a conflict with this case because here we're dealing with the one document?
Yes, I agree with that. And that's exactly how the fourth DCA, I think, dealt with it in each of its cases. They looked at those cases and said that they could be distinguished. But to the extent that they make an argument that there is a tougher standard in the second DCA, we would suggest that the arbitrary and capricious standard, the deferential standard of the fourth DCA, makes much more sense than that vested rights test in the second DCA. And this case is a perfect example of that. I mean, how do you determine whether a right is vested or not? The trial court looked at the issue of what was a vested right and decided that everything was a vested right. That can't be the case. So
can you speak, when we talk about vested rights, the lower court also had on the record some evidence of reliance, particularly Mr. Shaw was making an argument, it seemed, and putting evidence behind it, that he relied upon or was induced to purchase based upon the assumption that he would be able to, take back not only what his equity certificate was, but also what the assessments during his time as a member. We have bylaws here, which are subject to amendment, and you seem to be suggesting that once amended, you cannot have any reliance interest in what's stated in the bylaws because they are capable of amendment. But our bylaws here don't have what a typical contract has, which is that of merger. So that we take in all the statements that were made before the contract and say you can't rely on them. It's only what is in here. What do you do with that?
Well, I really don't think the reliance issue is a problem here at all. you've got that brochure. They take one sentence in that brochure that says that their assessments are going to remain 100% refundable, but it's clear in context that what that sentence is referring to is the existing special assessments. That amendment makes very clear that all of the previous special assessments remain 100% refundable. But it's impossible to look at that brochure and to suggest that the membership could have been misled about whether or not future acceptance were going to be refundable or not, because the entire purpose of the amendment, and look at the ballot that's also in the record, makes absolutely clear that this is all a matter of prospective special assessments not being refundable. I don't think there's any.
Under the sixth amended and restated bylaws, Part 4, Section D, it still says in both paragraph A and B, we're going to get 100% of all paid in assessments. It doesn't reference back to paragraph G or have any exception for paragraph G, which was added. It wasn't real clear in the record, but sometime prior to January 1st, 2013. Now, how do you align those two ideas if somebody reads what they're going to get a payout that still says 100% of assessments versus D that says not the ones after January 1st, 2013?
Well, first, that's an argument that hasn't been raised in this case. There's no argument by them that the bylaws are somehow ambiguous on this point. Their argument was that these existing members had a vested right and that the bylaws could not be amended. So I don't think that we have that issue in front of us.
Well, the judge's order does reference these. I think we have to look at what these people thought their rights were and what the arguments they made below. And I believe that the fact that you still have membership, Section D, that spells out 100% of them being made is a place where they can hang their hat. How would you say that they don't get that? They're 100% back.
Perhaps it's that in a future case, but not in this case. They haven't made that argument. In this case, it's no argument. I mean, the entire argument here is that the amendment was improper. There was no argument about whether the language of the amendment or the language of the bylaws as they were ultimately drafted was confusing or ambiguous.
But what the trial court said is you can't do this assessment. So that where they would hang their future hat is whenever they go to sell and ask for their money back, did they not then say, I still got 100% under Section D?
The trial court not only said you can't have these assessments being non-refundable. The trial court said you can't amend the bylaws at all. And clearly that has to be reversed. There is no question that under Florida law, even the best cases that they have all recognize that despite, except for this narrow exception for vested rights, the bylaws need to be amended. I see that I'm intruding into my counsel's times and my rebuttal time. So I'll reserve my remaining time.
May it please the court, Frank Shepard on behalf of the National Club Association. Let me join Mr. Brannick, if you will, and tell you and say that it is an honor for me as a 50-year lawyer to appear before the first session of the 6th District Court of Appeal. So, the National Club Association, my client is an amicus in this case, and I just want to take a couple of minutes to make a few points, and that's it. It's the breadth of the court's order. It's the breadth of the court's order that troubles the 460 private club members and more than 60 of which here in Florida. And that's the reason why we sought and received permission to write and submit a brief. And that is the paragraph that says plaintiffs have a vested contractual right to the terms of the bylaws in place at the time of their purchase of their equity certificate. It is that summarizes our issue. Virtually all private club documents have an amendability provision in them. And with respect to the context point that I wish to bring up, we have submitted, among other things, a survey done by the Florida chapter of Club Management Association, so demonstrating that there is in fact You know, every club in Florida that was surveyed has an amendability provision, and that has been used, and that it has been used. And as Mr. Brannick explained, that is really how these nonprofit corporations keep up with the times. Would like to just emphasize one legal point, perhaps two, but one for sure. And that is that in the club world, these are membership organizations, voluntary membership organizations. And the law in this area with respect to these type of organizations as set forth in the Everglades Protective Syndicate versus McKinney case out of 4th District Courts of Appeal, as it says, that give great deference to decisions made by members or boards of directors as they're democratically done. We tend to stay out of the business of what membership organizations want to do. The central issue.
That's one question. You framed the issue in the amicus brief. The question is simply whether the bylaws of a private club create vested contractual rights not subject to amendment. In your view, do you share the view of appellants in their initial brief that this is kind of one of two paths? Or in your view, is this kind of an accurate statement of the law as it stands in Florida with the cases that we've been discussing fitting into that rule?
Your Honor, we join in the argument of the Fiddlesticks Country Club in this case. I think you can probably waive benefits with the right language and so on, but this case can be decided very easily on the point that as we set it forth in our brief. This is a prospective charge. It's not even an amendment. Let's make that absolutely clear. It's not even an amendment. It's a $9,000 assessment. So it's not even an amendment that what we're dealing with, but we join in the argument made by Fiddlesticks.
Judge Shepard, so the issue that I raised may be better for you because you're here. I meet this on a number of groups where Fiddlesticks is arguing these facts before us here.
Mhm.
But would it then be acceptable for a membership, like in this situation, a majority to come in and say, well, I know we've always had this situation and always promised those first people in the club that they were going to get 100%. And then the next one in the club, we're going to get 80%. But you know what? We've diluted them to the point we don't think that's fair anymore. They shouldn't get anything more than the rest of us and just wipe the table clean. Would that be acceptable under your club's argument?
Your Honor, and if it's a situation where there was some fraud or bad faith, then yes, I would agree. But if it's totally agreed to by everybody, then I would respectfully disagree.
Okay, so basically going forward, what you would advocate the policy would be is those that have an advantage have got to watch their back. If too many people get there, they got to know that at any point that could be taken away. I'm not saying that's wrong, but
Yeah.
that's basically what you're advocating.
Well, yes, I think that people, I'm not saying watch your back. That's not.
Well, I mean,
Not the language.
what's your bank account? They could come in and take your equity share.
I understand your point. And I would just say that probably the easiest way to decide this case, I think, is on the perspective that this was a prospective charge, totally separate from anything having to do, totally separate from anything whatsoever having to do with 100% recovery or 80% recovery or anything of that type. This is a prospective assessment. Assessments are used, as we point out, trying to give some context to this. Assessments are used for capital expenditures, and capital expenditures, frankly, are what keeps the club going. It's not the annual dues that pay day-to-day stuff. It's the capital expenditures. And so from a standpoint of this particular case, it was perfectly reasonable in the context of everything that was done, just like in the share case that was mentioned, by the way, or not mentioned here, but in the briefs, that sometimes, as Judge Gross noted, the 4th DCA case that they rely upon, there can be a full a full reimagination, that's not the right word, but a full redo, if you will, of the bylaws, if agreed upon. The real problem here, let's go back to the beginning, the reason that we,
About a minute left on the time.
yes, I see that. I see that, and I will adhere to it, I promise you. Of course, this creates great difficulty for clubs as we have the way they want to argue different contracts with different people. And that would create chaos in the club and so on. And the statute, the Florida statutes, even support amendments of bylaws in the Florida Corporation Law, section 617.026. So we ask this court to join in reversing and give deference to private clubs that are democracy, that are models of democracy. Thank you very much.
Thank you.
Good afternoon. May it please the court. Scott Beatty on behalf of the appellees. I echo Mr. Brannick and Mr. Shepard's comments. It's a privilege to be the first in the 6th DCA. The issue boils down to whether or not the trial court was correct in granting summary judgment by finding that the appellees had a vested contractual right.
Counsel, can I stop you very
Yes.
quickly? You just spoke in terms of singular, vested contractual right. A few minutes ago, it was described as a sweeping order. And the reason it was described that way is because the trial court's order reads that the bylaws and all of their terms create vested contractual rights. It seemed to me from my reading of your complaint for declaratory judgment and your pretrial stip that you were also arguing in the whole that the bylaws created vested contractual rights. I think you used the terms in plural, contractual rights in plural. Is that your argument here today?
The argument is that the bylaws created a vested contractual right for those people who purchased their homes prior to 2013 to receive either 100% if they bought before 2000 or 80% of their paid-in capital plus 100% of the assessments that they would pay.
Understood. But are the other terms in the bylaws also vested contractual rights? Or are you arguing just singularly that this provision created a vested contractual right? It is different from other provisions.
That is what we're arguing in this particular case. And so there is this notion that has been raised that somehow this is the death knell for clubs about how sweeping this order is and the position that we're taking that bylaws can never be amended. Let me be clear. That's not the position. That's not what we believe the judge ordered in his ruling, because all of the cases that we rely on, the quartet of cases that we rely on, including the Feldkamp from the Middle District from the Second, talk about instances where it's appropriate for a club to amend bylaws. The share case, that's their big case, the share case. We don't have a problem with saying things like creating membership levels, charging different amounts of dues, saying that golf club members have to pay more than non-golf club members.
So counsel, what would the test that we would apply to the bylaws to determine which rights are vested and which rights are not?
Well, I think you would have to find and follow the rules in the quartet, so to speak, where they talk about when these folks came and they purchased their property. And by the way, contrary to what Mr. Shepard said, this isn't voluntary, right? In order for them to buy a home, they had to become a member of this club. And as you asked, I believe with Mr. Brannick, Mr. Shaw, there are documents, and these documents say your rights as a homeowner are set forth in the bylaws. And so what were those bylaws? The bylaws said you're going to get back 100%. And it said you're going to get 100% of the assessments that you're going to be paid. And that is what creates the vested contractual right, just like in Feldkamp. I mean, keep in mind, in Feldkamp and Veranda, the issue wasn't that they couldn't get their money back. That wasn't the issue in Feldkamp. The issue in those cases was the club had adopted a policy that said, we're not going to automatically refund.
Wait, so counsel, is the test that there were outside representations made that made certain provisions in the bylaws vested in other provisions? Now, I'm trying to determine what test we would apply so that we can parse out.
I think that the test is, and what the court have, keep referring to that because I don't want to say it over and over again. Say that the bylaws can establish certain vested rights that are not subject to change, even though they may be contained in bylaw documents that say they're subject to change.
And
So,
under what circumstances, I think is what Judge Mandela is getting at. Under what circumstances would bylaws that by their terms are subject to amendment create vested rights?
well, the best example is probably that first federal case. And that's not really addressed by them at all in their brief. But think about that there was a bylaw that says you can leave. You are permitted to withdraw your membership from this voluntary
Right,
organization.
1 in, 1 out, 3 in, 1 out.
Well, no, this is in the first financial,
Okay.
the banking one with the credit card merchant group. And they changed it and said, well, no, now you can't get out. You have to provide us 1 year's notice and for each month, right? And there was no capital that was paid in. They said, well, that's a vested right to not be assessed a charge when we decide we're going to leave on something less than a year's notice.
I think that your friend on the other side, the point that he made was that right emanated out of a charter that a bylaw was trying to amend. And I think when you talk about the 4 cases that you've also relied on, there's that issue popping up where whether it's a declaration or a charter, there's a right emanating from a separate document that is not subject to amendment that the bylaws then try to amend. Do you see those as distinguishable on that ground from the case
Well,
here?
but in the club cases, the 4, I mean, there were other documents. It wasn't just bylaws, wasn't just a constitution. The court goes through and talks about all these other representations or statements that were made that sort of go into that idea of making it a vested right. And
Let me ask it this way. So, Florida Supreme Court has defined vested right, and somewhat paraphrasing, but vested right defined as an immediate fixed right of present or future enjoyment. It's more than a mere expectation based on the continuance of an existing law, for example. First, do you agree that definition fits into our scenario here? So when we're looking at whether or not the bylaws created a vested right in this case, we should apply that definition. And if so, how do you think this fits into that definition?
the answer to the first is yes. And it fits in 2 ways. Number one, there was a promise that they're going to get back 100% of their paid-in capital. And there was the bylaw promise that said you're going to get back 100% of assessments that are paid. Now, they talked a lot about
How do
perspective.
you reconcile that with 4G? Like opposing counsel said it wasn't in the order, but if you look on page 5 of the judge's order, amended bylaws attempted to change the assessment refund provision, which is trying to cast doubt on something that's in the 6th amended bylaws, which is what both parties have said we're going under. So it's right there. It says any future assessments will neither be refunded nor assessments be added to the equity fee. How are you getting around that?
Well, because that was the proposal that was made in 2013. And so in
But it's
2000,
part of the bylaws. It's proposals. That's 5 years have passed before anything happened.
well, but Judge, there wasn't, and this gets into the statute of limitations argument, but there hadn't been an assessment. So 2013 says we're now changing it. So the bylaws that existed before that said 100% of paid-in assessments will be refunded was changed in 2013. But there had been no assessments issued by the club until the 2018 assessment. And it was with the 2018 assessment where the club said, all you people now that are getting charged this $9,000, you're going to have to either pay it or we're going to deduct it from you and you're not getting that back. So it was the only and first opportunity. If there had never been an assessment that was made after 2013, we wouldn't be here because we wouldn't need to be here because there wouldn't have been an assessment that was levied. And the assessment that was levied said to all of you people who purchased property here prior to 2013, you're not getting that back.
Why couldn't that have been brought earlier as an attack upon the amendment when it was made?
Because there hadn't been an assessment. And so there hadn't been an injury that was ripe for a court to, I mean, it's the whole standing issue, right? You don't challenge a law unless you're the person who's been arrested or subject to that particular law. There hadn't
You
been one.
can't challenge basically an older buyers act at the time it occurs.
Well, again, I don't think it was necessary because there hadn't been harm. There hadn't been harm to any of the plaintiffs until there was an assessment levy. That's all I can say for the reasons why it might not have been brought earlier, was that until there was an assessment, they were going to be getting back 100% of their paid-in capital and 100% of those prior paid. Because what they're saying here is, no, we're not going to say that you're now not going to get refunded for assessments prior to 2003. So there was no harm to them. But
So somewhat related to this, the first argument in the initial brief is, of course, that this is essentially a belated attack to the 2013 amendment. You raised the issue of waiver statute of limitations was not pled. My question is, was it necessary for that to be pled? The way that I see how the course of this litigation kind of moved, the complaint pled this as a kind of violation of the bylaws, with this vested, non-vested not really being the primary issue, it looked like, from the way the complaint was framed. It looks like this comes up kind of more in the summary judgment issue and then ends up in the final order as the issue of the fact that there was essentially an invalid amendment that affected a vested right. So to your view, when is the first time, if the association was going to argue that this was a belated attack, essentially, when was the first time they could have made that argument based on the pleadings?
well, I assume they could have raised the argument as far as early as prior to the time that summary judgment was entered. But again, I mean, I would go back to it doesn't matter because it's not untimely. I mean, they keep saying that this is a backdoor attempt, but again, I mean, a cause of action doesn't accrue until the last element constituting the claim accrues. And until there was an actual assessment that was not being refunded, there was no damage. Therefore, the cause of action wouldn't have accrued. So, I mean, that's the only, again, explanation that I think makes sense, because again, there wouldn't have been a need to challenge if there had never been an assessment that was levied that said, you're not getting this back.
What is your response to the argument that this is essentially two separate buckets? On one hand, we have the rate of redemption for the equity certificate, which is unaffected by this kind of singular assessment that's non-refundable, that allows references to equity certificate as essentially collateral for delayed payment of the non-refundable assessment, but the rate of redemption is untouched.
Well, I don't know that I appreciate a distinction there, because again, the bylaws specifically provided, and up until 2013, anybody who bought prior to 2013 was getting back 100% of the assessments. I mean, what's interesting is, so in 2000, when they amended the bylaws and said, we're now changing the equity certificate to 80%, anybody who bought prior to that, they continued to refund at 100%. Well, why? Well, because that was what the bylaws were at the time. And when people come into communities and there are bylaws in place, and those bylaws provide that this is what you're going to get, and you have to become a member of this club, that's non-negotiable if you want to buy here. then the people should expect that they have that vested right in what was told to them as a reason for why they purchased. And Judge Stargell, to your question before, the real concern here is, I mean, at some point in time, the number of people who bought their home prior to 2013 is going to be significantly outnumbered by the people who bought their home after 2013. And if you're to take the position that the appellants want you to take, even those people who were bought or who bought and were told 100% of your equity certificate can be refunded, their position is we can take it away.
Then what do you say to their argument that they knew in the bylaws? The bylaws said they could be amended. Therefore, you're on notice. For right now, you get it, but later on, you don't.
Well, then I would go back to what the four cases in those club cases all say, because that's the exact argument. These clubs came in here and said, well, these things are all subject to change.
But if they wanted to, they could have went in and argued with the board. Fine, we'll agree, we'll vote for it, but let's put in there a different class of membership. Let's put in something different so that we are protected. But that didn't happen. So going forward, their argument is it's bylaws, they can be amended, they can do whatever they want to.
Well, then I would suggest that developers and real estate people that want people to buy in their communities shouldn't make promises like that. You're going to tell somebody that you've got to pay $100,000 and all of your assessments are going to be refundable, and then pull the rug out from under you once they're in the home. If that's the position that the court and Fiddlesticks wants to take, I mean, that would be shocking, because we don't operate in a, I don't know any other way to say it. We don't operate with a mob rule mentality. That's not.
You agreed to a document, right? That has a simple majority provision, right? And bylaws can be of two natures. They can be, internal governance documents. They can also be documents that talk about the rights that we have here now. Isn't your argument essentially changing the terms of the bylaws by giving specific members veto power?
No, quite the contrary. I'm saying that the bylaw with respect to those people who have that vested right can't be changed. And that people shouldn't be able to come in, even if it's for valid economic reasons. I mean, look, there's no doubt that the reason that the clubs in the Veranda and Feldkamp did what they did in 2008 was the direct result of the disastrous economy that we had in Southwest Florida. And the court said, sorry, that's not a valid reason. Not when somebody comes in and buys property or buys a membership certificate and has a vested right.
Do you agree that the right that you're seeking to enforce only emanates out of the bylaws?
Yes.
Okay.
Yes. And there was some talk or discussion about perspective, that, oh, well, this only applied to perspective. We were still going to give back all the assessments that were paid. Really doesn't matter, because if you think about it, when somebody comes in 1997 and buys a piece of property with a bylaw that says you're going to get 100% of your equity certificate plus all paid assessments, it only applies to prospective assessments, right? Nobody buying a piece of property that's got existing assessments on it. So it doesn't matter if the court's
What
going
do
to
you think
find.
distinguishes the redemption rate from any other financial obligation in the bylaws, whether it's membership, whether, let's say, there's bylaws with a minimum monthly that you have to spend at the club, green fees, et cetera?
I think those would be considered terms of membership. And what's interesting is the share case, which they push. They say that's the deferential approach. Well, if you read it, though, the share opinion specifically says we're not talking that you can make changes to membership terms because those don't involve vested rights. Even the share case, the star of their argument and briefs, makes an exception for vested rights. And Share did not deal with vested rights. And I think if this court is going to adopt the position that the appellants want you to take, you're going to have to say, well, of the trilogy, the 3-second DCA cases were wrongly decided because we have bylaws that are subject to amendment. And I think you're going to have to say, well, Share, even if it involved vested rights, we think that clubs can do whatever they want to do because they're subject to amendment, even if it involves a vested right. The courts, the cases that we cited have consistently carved out and made an exception between vested rights that are not subject to change and non-vested rights like membership rules, regulations, those sorts of things that are subject to change. The judge characterized this as a vested right that emanated from the bylaws. The judge properly granted summary judgment, finding that these people's right to receive 100% of paid assessments was a vested right and that this court should affirm.
Thank you. I did this. I haven't done the clock in a while. So y'all, you had about 5 seconds left. If you want to use just a couple minutes to make any rebuttal points you'd like to
I'll
make.
be very brief, Your Honor. I appreciate it. We appreciate counsel's concession that they're not arguing that every bylaw amendment would be effective vested right, but that's not what the trial court said. So at the very least, I think that's an effective concession that this court needs to reverse and fix that problem with the court's order below. The tougher question here is what test applies. And I don't think counsel has provided you, Your Honor, with any reasoned analysis of how you determine when a right is going to be vested or not, how you determine which amendments are enforceable or which amendments aren't enforceable. He says that all of the promises in the bylaw, everything in the bylaw is a promise, and you can't go back on your promise. But that's just going back to the original argument that you can't amend the bylaws at all. We think that the proper test is the arbitrary, capricious, and bad faith test that was used by the Share case and the Hamlet case. It fits perfectly here. There were very sound economic reasons for what the club did here. They haven't argued with those economic reasons. They haven't argued that this was arbitrary and capricious. They haven't argued that it was in bad faith. And they certainly haven't suggested that this was some sort of takeover or tyranny by the majority. This was a very reasoned decision made by the membership. And the reasons are set forth in great detail in the record. And we talked about them in our brief. And if you're going to apply this vested rights test, we think that the case still goes our way because this amendment was prospective in operation only. It only went forward, was only forward looking and not retrospective looking. And just like statutory amendments can be forward looking, so can the bylaw amendments of the membership. And I think what's very important is that the 2013 amendment did not touch the value of the equity certificates at all. They still remain refundable at exactly the same rate that every member agreed to when they joined the club. This was only about the special assessments, only prospective in operation. So it didn't impact a vested right. It was prospective only. So for those reasons, we think that the trial court needs to be reversed.
Thank you. Okay, thank you both. We'll move to our next case. We have case 230388, Carrie A. Potter et al. Versus Fiddlesticks Country Club Inc.
And may it please the court. The issue in this particular case emanates out of the case that you just heard, where a summary judgment was granted in favor of the appellees in that case. And there was a motion for fees and costs that was filed by them that was denied by the trial court. So this is a narrow issue in the sense that we sort of have, obviously we have Stockman. We know what Stockman says. We don't have any issue with Stockman. And then we have the BMR case that the appellees, and if I mess up my nomenclature, I apologize for that at the outset, out of the second that they rely on to say why fees shouldn't be granted. So there is no dispute that a request for fees was not contained in a plea.
You agree in any pleading?
There was no pleading, as that term is defined in the rules, that made a request for fees. So to the extent that Stockman says that you have to have a pleading, okay, we didn't meet that. Agreed. The issue, though, is Stockman contains an exception, and that exception is built on the concept of notice and preventing unfair surprise, and says where a party has notice that their opponent is claiming fees and either acquiesces or doesn't object, that can be a basis for fees.
So I appreciate that framing. All right. Do you, with it framed that way, do you still stand by the proposition that this is, we're reviewing this de novo, or would you agree that it's abuse of discretion?
Well, I think to the extent that there may be an interpretation of law, I think it would be de novo, but I mean, clearly, I think the award or denial of fees is abuse of discretion. But I think in this particular case, the trial judge found that what the appellants did in this particular case either didn't comply with Stockman or he was compelled to follow the BMR ruling in denying fees. Because again, in BMR, interesting, they tried this same, for lack of a better word, tactic, right? Where they sent a notice of intent to seek fees. And the second district in BMR said, yeah, not controversial, not disagreeing with it. A notice of intent is not a pleading. Okay, fine. BMR then analyzed that exception that Stockman created to determine whether or not that applied in BMR. Excuse me. And one of the things that the party seeking fees in BMR said is, well, wait a second. They had notice and they didn't object. And it's way at the end of that opinion. And the court said, well, we don't buy that either because they actually did file a written objection because fees weren't pled. Well, that's the sort of distinction in the situation in BMR, and why I wouldn't just tell you, well, BMR means you've got to affirm, because there wasn't an objection that was raised by the appellees, by fiddlesticks, when that notice of intent was served. And it's important to keep in mind that both Stockman and BMR, the request for fees were made way after judgment, both cases. Here, there was a request that was made in 2020, and then again in March of 2021. And so the case was still in its proceedings, and there was never anything that they filed, Fiddlesticks filed, saying, we object to this. They waited until there was a hearing to say, well, we clearly object to entitlement
Counsel,
because
if
it wasn't
the
pled.
document is for the exception, is notice, correct?
Correct.
If that's the fundamental premise, are you seeking fees from the inception of the lawsuit, or are you seeking fees from when notice was given?
From the inception of the lawsuit.
Okay. And how is that? I understand how Stockman held, but how does that comport with the theory that notice matters? If we go almost 2 years without giving notice and generate, I'm assuming, lots of attorney's fees during that period of time.
Well, I'll tell you why. Because what would the alternative have been? So if there had been an objection to them in 2020, after the lawsuit had been filed and we doing some things. And we file a notice of intent to seek fees. And they said, well, we object to that because you didn't plead it. What could the appellants have done? They could have filed a motion and said, we want leave to amend because we want to include a claim for fees. And unless it was on the eve of trial or the privilege to amend had been abused or amendment was futile, the court would have granted that. Well, if the court did that, then the court wouldn't say, well, you only get fees from the date of your amended complaint.
But counsel,
So,
wouldn't they argue that back to you, that the opportunity to object presents during a motion, not just to a notice, that it's your owners, it's your cause of action? I mean, isn't that what they would say?
well, I'm sure that's what they would say. But, and in BMR, that's what they did. The party opposing fees filed a notice to put them on notice, to put the party seeking fees on notice that, hey, this isn't a proper, you never requested in a proper pleading and we're objecting. I mean, and the thing is that they had asked for fees under the exact same statute. I mean, this whole concept of notice and preventing surprise, when Fiddlesticks in their answer says, we want fees for the exact same statutory provision, where is the surprise?
You're arguing that in any case, if one party argues for fees, the other one should automatically be entitled to them?
No, sir, I'm not saying that because there may be different reasons for it. But if the hallmark of Stockman is to prevent surprise.
But it wasn't another hallmark of Stockman, the issue of whether just the existence of a statutory basis for fees provides notice of fees to opposing party, and Stockman rejected that. Hence the pleading requirements that come after.
Correct.
So I have a question on the notice to intent, the notice of intent to seek fees. There's the argument that that's not even seeking fees. So in other words, there wouldn't be a basis to object because all this was a notice of an intent to seek fees. One could reasonably interpret that as somewhere down the line in some pleading or maybe through amendment of pleadings. What is your argument that this document, one, is legal fiction, and two, only provided notice of an intent to do something in the future rather than an actual claim for fees?
I don't know that I would characterize it in that fashion, that it's a notice of an intent to do something in the future that's going to seek fees, as opposed to a notice to them that we intend to seek fees in this particular case. If that makes sense. So I don't think it is we're going to do something in the future, as opposed to we are telling you that we will be seeking fees.
Mm-hmm. So is there a case that you can think of, I guess, which case of the cases that you cited, was there this kind of the lack of an affirmative statement? So here, in most of the cases where there was a waiver, there was an opportunity for the litigants to make an affirmative statement of either, that litigation schedule is fine with me, or I don't object to hearing from the attorney fee expert. We have these moments of an affirmative statement that are seen as essentially waiver. Here we just kind of have the absence of anything happen. There was no objection, but there is also no affirmative non-objection, so to speak. Can you think of a case that has that scenario?
I can't, because I probably most assuredly would have included it in the brief. But I think that to the extent that BMR and Stockman were both post-judgment, I think that's really a key distinction here in why the courts could have said, well, wait a second, right? Now that you've got judgment and you've won, now you're going to ask for fees? And that's just not, this again was done before judgment, before the summary judgment was filed. So, I don't think that, again, if the court wants to say, and I don't dispute or have necessarily an argument with the court concluding as BMR did, notice of intent is not a pleading. Okay, we'll accept that, but it's still, BMR doesn't address that issue of that Stockman exception. And here we have a party that sent a notice of intent that said we're going to seek fees, same fees that the other side was seeking, and it was silent. And the only next opportunity, so to speak, that the issue of entitlement to fees would have been able to be raised is when it was after summary judgment was entered. And you don't go and ask the court.
So you've acknowledged somewhat that we'd be breaking some ground if we created some sort of acquiescence by silence rule. I am a little concerned with that, particularly when a notice of intent is not authorized by any rule, that another litigant would then have to take some affirmative action, expense on behalf of their client to point out to the judge that somebody's filing something that isn't authorized. We don't have any similar precedent of kind of affirmative obligations to move to strike, that sort of thing, although there's a procedure for that.
Right.
Why is this not creating some problematic precedent moving forward?
Because I think that, this concept of acquiescence, right? I mean, it all depends on how you want to define acquiescence. So there are cases and situations where issues of attorney's fees were included on pretrial statements. Issues of attorney's fees were, raised in case management orders and things like that. And they said, well, wait a second, at some point, you need to say, hold on. And again, I have to go back. If that was an issue, why wouldn't, Fiddlesticks, I'm sorry, the appellants, the homeowners here, could have just moved to amend. But they never got that, hey, we're opposing this because this isn't a proper notice and we're not acquiescing. And then they could have amended. And the amendment, again, they could have simply done nothing but add a claim for fees.
I guess why would that not be done at the litigant's peril then, rather than putting the burden on the opposing party to make some affirmative action?
Well, because I think it ultimately, again, boils down to this concept of notice, right? And that you don't want people to be surprised by all of a sudden being told, hey, by the way, we're seeking fees. And I can understand, right? So maybe you're not quite sure when you first take a case that you want to make a request for fees. And then as the case progresses and you are on, the night before your trial, your bench trial, your summary judgment, right? That you could say, hey, I think I want to ask for fees now that I feel more comfortable in my case. I mean, that wouldn't be considered proper notice. I mean, the procedure may be proper, but it still wouldn't be notice because you can't send something to somebody a day before trial or a day before a hearing that's on a dispositive issue. Again, that's not what happened in this case. There were two of them that were filed well before the motions for summary judgment were filed.
So I was under the understanding that the second notice was filed 4 days after the motion for summary judgment was filed. Is that incorrect?
I'd have to look. I'm not going to dispute the date. And if that's the case, then I would stand corrected. So I don't want to make a mistake in my recitation to the record. So, I mean, unless there are other questions, again, I think that the process that was done, was it ideal? No. But did it provide notice? Yes. And did it provide an opportunity for them to object at that time? Yes. And that's why we think that what happened in this case falls within that exception set forth in Stockman and BMR, and why this court should reverse. I see I have 5.5. I'll reserve 5 minutes for rebuttal. Thank you. Yeah.
Good afternoon, Your Honors. I apologize for my voice. Ahead of time, I was on a plane last couple of days and I'm a little scratchy. Sorry. T.W. Anderson, counsel for the appellee here, Fiddlesticks. My law partner, Rebecca Rodriguez, is with me this afternoon as well. I'll be the only one arguing on this matter, though. Your Honors, the order on appeal here today should be affirmed for two reasons. One of them is sort of off the table now, and that is that everybody agrees that the request for fees was not in the pleading. So the second reason why this should be affirmed is because the exception to Stockman does not apply. Stockman lists two examples of exceptions to the general rule. One, the party who was seeking fees included their request for fees in a pretrial statement. That didn't happen here. In fact, we have the opposite. The appellants filed a document titled Statement of Facts, Disputed Facts, and Issues of Law to be decided by the court before they filed their notice of intent. And in that document, they didn't raise at all the issue of attorney's fees. The second example, I should say, that was raised in Stockman was that the parties agreed jointly that the court should consider the fee issue at the trial. So we don't have that here either. All we have, as you've all pointed out, are the two notices of intent. And we've argued in our brief that these notices of intent are nothing more than legal fiction. Judge Sasso, as you stated, they're not authorized by any rule of procedure. There's nothing that provides for a party to file a notice of intent to seek fees. And I think it's worth pointing out that the hearing that was had on the fee issue was on the motion for fees, not on a notice for fees. I think that's important to remember.
So what is your response to the argument that by silence basically lured the other side into a situation where they thought that their claim for fees was valid and alive?
Well, I think that by silence is not entirely accurate because the appellants here sort of flip-flopped in what they did, right? They filed a complaint with no request for fees. Then before they filed their first notice of intent, the parties go to mediation. Mediation was impassed. Things could have been a lot different at mediation had there been a claim for fees in play at the time. I mean, one of the things that the cases all talk about is that parties need to know what they're facing. This is a claim for fees that's probably some six-figure number, right? So this is really no different than someone asserting a breach of contract claim and then later filing a notice of intent to seek damages for a breach of the covenant of good faith and fair dealing and de facto amending their complaint by filing a notice, right? This is bringing in a whole new claim by notice, by a purported notice, rather than by actually amending, which would have been freely given at the time. They could have moved for leave to amend at any given time during these 2 years from the time the complaint was filed until the summary judgment was issued. I don't know if that adequately addresses your question, but
yes.
The cases that interpret Stockman and as sort of clarified by Green versus Sun Harbor and that progeny, they all talk about the fact that the pleading requirement in Stockman should be strictly construed and that this exception should be very rarely used. And I think one of the cases that the appellant cited in their brief is kind of a good example of where that exception should be rarely used. That's the Bank United case. In that case, the party who sought fees did not seek fees in an answer or any pleading. They filed a motion for judgment on the pleadings where they sought fees. They filed a motion for summary judgment where they sought fees. And then the parties litigated the fee issue for 3+ years. The party that sought the fees filed a motion for fees, no objection from the bank. They went to a hearing, no objection from the bank. It wasn't until 3 years after entitlement was granted at a hearing on the to determine the amount of attorney's fees to be awarded that the bank objected for the first time. I think that's acquiescence. That went on for 3 years. So here we have no notice in the complaint. Then we have a pretrial statement with no request for fees, mediation, impasse. Then we have the first notice of intent to seek fees, which sought fees under the wrong statutory section. And then we have several months later, we have a case management order that's entered, no mention of attorney's fees. Several months later, we have the motion for summary judgment, no demand for attorney's fees in the summary judgment motion. I actually re-reviewed the transcript of the hearing last night, and I made the PDF searchable, and I hit a Control F to search for the word fee. There wasn't even a request for fees at the hearing on the motion for summary judgment. It wasn't until the proposed order was submitted to the court, which I understand was signed verbatim, that the fee issue was addressed at the summary judgment phase. So then after summary judgment, as I think Judge Nardella, I think you pointed out, the second notice of intent to seek fees was filed 4 days after the summary judgment motion was filed. So we have this flip-flop back and forth. So silence, did they abandon their request for fees after they filed their first intent? When they filed their summary judgment motion, didn't ask for it? And did they revive it again when they filed the second notice of intent? You know, we as lawyers have rules of procedure we have to follow, otherwise chaos ensues. And allowing a de facto amendment to a complaint to be had by filing a notice of intent would just result in chaos. Your Honors,
What is your position on the standard of review?
my position is that it's an abuse of discretion. There's no interpretation of a contract or a statute here. Nobody's disputing that there was a fee claim in play, or could have been in play, right? That, and I think to get to de novo, the court has to either determine the contract and was there a right to fees if properly pled, or determine whether there's a proper statutory basis for it. I don't think that's an issue here. I think that the issue is abuse of discretion. Did the trial court abuse its discretion in denying the fee motion when it wasn't pled? So one of the other things that the appellants raised here was that we Fiddlesticks raised a claim for fees in our pleading, and we did. We properly raised that claim for fee in the answer. Stockman talks to that point itself, and on I think page 38 of that opinion, page 838, it says that just because one side raises the fee issue, it doesn't cure the other side's failure to do so. So you know, that in and of itself doesn't absolve the issue of not raising it completely. Your Honors, unless there's any other questions, we'll rest on our briefs, and we ask that the order of appeal be affirmed.
Thank you. 5.5 minutes for the remaining.
Yes, and I shouldn't need all of it. The exception that Stockman recognized says where a party has notice that an opponent claims entitlement to fees and by its own conduct recognizes or acquiesces to that claim or otherwise fails to object to the failure to plead entitlement, that party waives any objection to the failure to plead case for fees. The issue in this case is twofold. What does it mean to say a party has notice? And what does it mean to say that you either acquiesce or, not and, or otherwise fail to object? Stockman doesn't talk about, well, what does notice mean? BMR suggests maybe that doesn't constitute notice, but it didn't have to address the A, notice, because it found that the B, acquiesce or failure to object, wasn't met in that particular case. So if this court can conclude that the A was met by providing a notice of intent to seek fees, and the B was met because there was a failure to object to entitlement to fees, because there wasn't a timely or any kind of objection to that until we had the hearing. I think that's really where the rubber meets the road on this case. If the court doesn't feel like a notice of intent meets notice, then we're done. If the court finds that there wasn't an obligation to object, then we're done. Unless there are questions, Judge, thank you. I have nothing further.
Thank you very much. With that, we'll be in recess. In case y'all don't know, there is a reception following circuit 4. Love to see you all there.